Something to put behind that. All right, just getting things started here as far as the streaming, and we'll get going. I'll do it on Facebook as well. Share screen. Share screen, share. All right. What's up? All right, get that out of the way. Move this over. And make that a little bit bigger. And we are ready to go. Not long ago. Title graph. There we go. Live chat. Come on, as your free turn on. Stand your ground. Why can I not share it to groups? Oh well. Alrighty, it's 6 o'clock, 6:01. Got a couple people on the different platforms here. Alright. We'll get a couple minutes here to get everything fired up. Looks like Facebook's good, YouTube looks good. Unfortunately, I'm not, other than live streaming one thing, or some stuff for work, I'm not great with this multiple platform thing, so you'll have to bear with me here. All right. No, I don't want to end it. I want to go to, there we go. Alrighty. So basically, what are we here? What's this all about? My name's Justin Goggins. I teach concealed carries and under the name nwadefense.com, so that's the website and blog. You also might be watching this via the Practical Tactical podcast as well. Basically, tonight we're getting together to talk about primarily the stand your ground law, as they will, or really it's not a separate law. It's amending the current statutes, and we're going to talk about that. We offer concealed carry training for basic and enhanced as well. And also we do private instruction as well, as far as the kind of the three disciplines, if you will, handgun, shotgun, and kind of like the tactical rifle, AR-15, defensive rifle, stuff like that. We don't do like the long-range sniper stuff, but the basic stuff there. So on this one, I'm going to have to show you my screen because I can't simulcast to both. So, alrighty, so we're talking about stand your ground. So basically, the governor has signed this into law. I believe it was March 3rd, and he made, basically there are two changes to 52606 and 607. 606 is your use of physical force in defense of a person statute. It's kind of your general overall use of force statute, and it's where it's kind of where the whole use of force in general, whether it's someone shoving you all the way up to a physical confrontation, it kind of covers that spectrum. So it says a person is justified in using physical force upon another person to defend himself, herself, or a third person. And this is where we also get our third person doctrine, where you can act on other people's behalf, from what the person reasonably believes to be the use or imminent use. Once again, this talks about how you don't necessarily have to wait till somebody hits you or stabs you or shoots you. You can act preemptively and take action if necessary to prevent it. Where we at? The imminent use of unlawful physical force by the other person. So once again, it has to be unlawful. You can't resist being arrested by the police or something like that. By the other person, and the person may use a degree of physical force that he or she reasonably believes to be necessary. So this is where we get our proportionality statute, so if someone shoves you, it doesn't mean you can turn around and hit them in the face with a baseball bat necessarily. Whatever your response to that force has to be kind of an equal amount of force. Not exactly equal. You can, I like to use the example of someone like on a 1 to 10 scale, 11 being shoot them in the face. If someone grabs your wrist with like a level 2 force, you can use a level 3 or maybe even level 4 to overcome that. But that doesn't, just because they unlawfully grabbed you doesn't mean you can crank it up to 11 and shoot them in the face. You can use a reasonable amount of force to overcome what's being done to you. Now, previously, it had said in this statute that it didn't have anything about retreat on this statute. It specifically mentioned retreat in 607. So this is what they've added to the statute of 606. A person who uses or threatens to use physical force as otherwise permitted under this subchapter does not have a duty to retreat before using or threatening to use physical force if the person is lawfully present in the location, not engaged in criminal activity that gives rise to the need of use of force, and in a gang, not engaged in any activity in the furtherance of a criminal organization or enterprise. So this is the big thing that's changed. Specifically, it wasn't present before, but it basically says, hey, you don't have to avoid the necessity of using force. What it really comes down to, you still have the same justification. If someone is doing something to you and it's an unlawful physical threat, you have the same justification that you did before. Nothing has really changed. It's just taken away the mandate that you need to retreat. And there wasn't so much a mandate on the physical force as it was deadly force. And they put it in both places. I'm going to go ahead and cover the deadly force one, and we can kind of address them both the same, because it really is, as far as the legal ramifications, they're both basically the same. So here's our deadly force statute, 607. And basically, like I said, you got to focus on this part right now. You're justified in using deadly physical force upon another person if their person reasonably believes that the other person is using or about to use unlawful deadly physical force, which the state of Arkansas just defines as anything that a reasonable person will believe is likely to cause death or serious bodily harm. So that's when you're justified in using deadly force to stop a deadly force threat. What they have, like this is what it used to say, that you may not use deadly physical force, and this is part of 607 on deadly force, in self-defense if you know you can avoid the necessity of using that deadly force with complete safety by retreating. So prior to this, if you knew you could avoid it, you had to avoid it, basically. But the question was always, how do you prove this? And we'll talk more about that later. So this was all removed, and now it says in the deadly force statute, a person is not required to retreat before using deadly physical force if the person is lawfully present at the location where the deadly physical force has been used, has a reasonable belief that the person against whom the deadly force is used is an imminent threat to cause death or serious physical injury to the person or another person. Once again, we still have the initial aggressor issue, and it also goes into more details about if you're basically committing a crime or engaging in criminal activity. Because here's the thing, too. If they didn't put this in there, if someone broke into your house and you pointed a gun at them and said, get out of my house, they could say, oh, I have self-defense. So they have to put this in here to kind of foresee potential issues in the future to try to prevent those kind of issues in the courts. So they had to put in there, if you're actually committing a crime, that kind of stuff, then you can't turn around and claim self-defense if your criminal activity is creating it. So, like I alluded to before, we still have the aggressor issue, meaning you can't be the initial aggressor. And the state of Arkansas just talks about being the initial aggressor. If you look at multiple states and multiple court cases, I think you should probably be responsible to put in there either a mutual combatant or equal participant or instigator or escalation, so forth and so on. Because at the end of the day, it's really hard to prove who said what first. So it's absolutely imperative that just because the other person says, F you, oh, he started it, we're good to go. Well, no, F you, and then blah, 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 you both escalate into a confrontation. Even you can read this and say, well, I wasn't the initial aggressor. Okay, how easy is that going to be to prove in court? It's not going to be. So you don't want to play that close to the margins and really run that fine line. We want to make sure that we are not a equal participant in the altercation and in any way escalating it or putting fuel on the fire, no matter who starts it, because at the end of the day, it's going to be really hard to establish those facts, and you're taking serious risk if you play the game that way. It's a dangerous way to play it. So, as we look through this, the justification has not changed. Absolutely has not changed. You still have to justify your use of physical force or your use of deadly force before you use it, and none of that has changed. I don't think that on March 2nd versus today, this law should really change anything that you would do in one of these kind of situations. It really should not. And if you think about it, if you're justified in defending yourself, you should be justified virtually anywhere you're at in any situation. What it has done, though, is given you more protections that if you happen to have to use physical force or happen to have to use deadly physical force, once you're in a court and you've made that justification, it's basically taken away from the prosecutor that added burden that they can hit you with, saying, well, yes, Justin, you were justified in shooting that armed robber that was robbing you, but we need you to prove to us that that it was absolutely necessary and that you couldn't have avoided the situation. And if you look at that, it's I think it is an unnecessary, excessive burden to put on somebody after they've already justified to you that the lethal force or physical force was necessary and justified, to then add to it, to add to it another burden of proving that you had no way of retreating or avoiding the necessity. So the average person that gets involved in one of these use of force situations or self-defense situations, this changes to the law should not affect you. The only thing it really does is going to help you if you have to go to court and fight it out with a prosecutor. It's taking one basically weapon away or tool away from the prosecutor to use against what should already be a justified shooting or a justified use of force, is basically what it is. And very few people are going to dive down into it to this much detail to really grasp that, to understand it's not saying that two guys in the middle of this Walmart parking lot can now go to blows and go to guns and shoot each other, and we're just going to let that happen. There'll be blood in the streets. That's not what's happening here. That's not what's going to happen. And here's a news flash, guys. Laws don't typically affect the law abiding because they are following the laws. They're good people. They're not doing these kind of things. So it is typically a non-issue. And the biggest thing I want you guys to remember, it's really not going to change anything you're going to do going forward. We need to avoid killing people and using deadly force. We should at least morally be doing that. Or if you don't, if it's not a moral thing, it's just a simple logistical and money thing, that even if you're justified, you pull your gun and smoke somebody, you might be completely justified and win the court case and win the civil case, and hopefully the news media doesn't destroy your name. You might win most of the battles and still be broke. Now you can't get a job because your name's ruined in the news. And there's a lot of cost associated with this, that if you can avoid having to use force, especially lethal force against somebody, I'm telling you, it is time, money, and it's a good investment to let the ego take a few blows and walk away or avoid escalating a situation. All right, let me see here. I don't have any... Sorry, I don't have any chats there. Let me switch over here to the Facebook side and see if I've got anything. Okay. Somebody also asked to talk about... hello, Justin? Justin? Asked me to talk about basically open carry or constitutional carry, all that kind of stuff. So, a couple issues here. What is really... Oh, I'm sorry, I forgot about this lawfully present thing. Yeah. So this brings up a question that if you have, let's say you're carrying a firearm, let's say without a permit, and you are standing on the... like this one right here with the picture, this is from a Fayetteville trail, carrying a handgun or firearm. If you're standing by this sign in, I don't know, Kessler Mountain Park or Wilson Park or whatever, or on their trail, and now all of a sudden somebody presents a lethal force threat, that now you have to retreat. I really don't... I mean, I could maybe come up with some crazy hypothetical situation where, yeah, I guess. But here's the issue, guys. Like it was prior to March 3rd. If someone is literally about to be killed or seriously harmed, you can defend yourself. It doesn't change anything. It shouldn't change anything. And outside of some situation, if you're picking a fight with somebody on the Fayetteville Trail and you're escalating it, well, you still shouldn't be doing that anyway. So I don't know how this really changes things that much, except the guys out there that are just absolutely anti-concealed carry permit, that say this is some backwards legislation that seems like it's good, but it's really bad because if they're quote-unquote constitutionally carrying, now they have to retreat. And I'm like, I just don't see it that way, guys. What I see lawfully present is we don't want criminals to be able to commit crimes and then turn around and shoot the victim and claim self-defense. That's how I interpret that. That's how, if you read the other parts of it where it goes into detail, where it's talking about, lawfulness, it's talking about you can't claim self-defense when you're robbing somebody or doing gang violence or some other committing a felony. So I don't interpret this that is you have to try to outrun a guy with a knife if you're on the Fayetteville Trail because this says you're lawfully present. I just don't think it's an issue that's going to really affect things. I think people overthink that a lot as far as the whole lawfully present thing. And you still have, like we'll go ahead and talk about that. The way things currently are, there's lots of different terms you've heard, whether it's constitutional carry, permitless carry, or even open carry. It all really stems to the same thing, which was a change in the law in 2013. And the biggest issue was they added these words right here that in order for you to charge with the crime of carrying a weapon, which is a handgun, knife, or club, you had to be carrying it with a purpose to attempt to unlawfully, and that's the biggest thing, unlawfully employ the handgun, knife, or club as a weapon against a person. So, and you can make the same, the same statement here that these people say now you can constitutionally carry anywhere. Well, unlawfully, if you're on the Fayetteville hike bike trail and you walk by that sign that says you're not supposed to be having guns, are you not unlawfully employing a handgun if you use self-defense on the trail now, carrying your constitutionally carry? You could say the same kind of logic. So anyways, I think people get a little too into the weeds with this thing, especially when realistically, if it comes down to you having to do self-defense or some kind of thing like that, it should be pretty clear cut. I think it was James Yeager that said, and I use it in my classes a lot, you should never use deadly force to take a life. You should only use deadly force to save a life. And whatever hypothetical you come up with, if it fits that narrative that, why did you shoot this person? Because if I didn't, someone else was going to be dead or seriously injured, or I was going to be dead or seriously injured. Then a lot of this stuff, all these little details and minutia are really of no consequence. But back on the topic here of the constitutional and permitless carry and open carry. So this was tested in Taft v. Arkansas, and it basically said, no, not basically, they literally said merely possessing a weapon is not a crime in the state of Arkansas, which, hey, this is a good thing, guys. I mean, this is pro Second Amendment. This is good stuff. We want this kind of rulings, and frankly, we need the laws changed and revised, and it will make a lot of them just need to be removed. But your Attorney General, I think I'm going to mess up her name. I think it's Rutledge. Yeah, Miss Rutledge clearly said this didn't get rid of concealed carry permits. It really, there have been many examples of case law. I've got the two main ones here, which is Taft, and then we have one more we're going to talk about. I don't know of a lot, and I haven't sat here and done an exhaustive study, but it appears that most of the prosecutors in the state after these last two cases have pretty much gotten in line, because prosecutors don't really, I don't speak for all prosecutors, but most don't want to get their case overturned at the state Supreme Court. So they try to abide by jurisprudence and case law of even out of other jurisdictions as well, if they think, it might be something that would be used to get their case thrown out. So they try to follow the guidance of the courts. So the one thing that has happened is there was a resolution. Now understand, this is a resolution. It's not law. Now it is your Senate's interpretation of that court case. But I'm telling you guys, the way this works is the state Senate, state House pass a bill or a House bill or a Senate bill, and then it goes to the governor's desk and he signs it. That's how it becomes law. A resolution is basically just saying, hey, this is what we think about this, or this is a clarification. So it's good, it's helpful, but it's still not technically a law. So even though it said affirming that Arkansas is a constitutional carry state, no permit required to carry a handgun, either concealed or unconcealed. That's good, it's going in the right direction, but it still leaves a lot of unanswered questions, a lot of conflicting information, and the biggest issue is the prohibited place question. Does this supersede prohibited places? Which obviously I don't think anybody wants to go that far. Even the lawyer for this next case we're going to talk about said, I ultimately think most of these prohibited places will be ruled unconstitutional, but they haven't been yet. So, and if you want to, hey, rock and roll. I will start a GoFundMe for your legal fund, and we can have at it. But that's an expensive process that me personally, I don't want to test. It's just the cost could be really high. So this was in Petrie v. Arkansas. Somebody else asked whether there was other cases. This actually comes out of Fayetteville, Arkansas. And Petrie was a guy, he was drunk at a bar and basically got into altercation there. I think he tore a door off the hinges or broke some stuff, got mixed it up. And long story short, Fayetteville police arrest the guy for public intox and disorderly conduct. And they're handcuffing him, putting him in the cop car and patting him down, emptying his pockets, and all of a sudden, boom. They said, hey, do you got any knives, guns, anything on you? He goes, yeah, I have a gun in my pocket. He had a loaded Glock 43 in his front right pocket. Now, they charged him with carrying a weapon, the charge. Now, here's the issue. No one knew he had the gun. The cops didn't know until they were patting him down after he'd already been arrested. So it really wasn't an element of the crime other than it being in his pocket and nobody knew. So this was the question we all wanted to have answered with this case. Does carrying a gun without a concealed carry license necessarily violate the law? We're like, yes, let's finally have it out. There's a problem, though. The Arkansas Court of Appeals are like, you know what? That's not the issue here. That's not the question here. The question is, did the state prove that Petrie possessed the gun with the purpose of using it to an unlawful end? Like we talked about before, the bottom of that statute said the criminal intent part of this statute, you have to prove that you had it for an unlawful intent. And there was nothing there. They never mentioned the gun other than, yeah, he had a gun in his pocket. He never threatened anybody with it. Nobody knew. So the Arkansas Court of Appeals threw it out and said, no, this is not a good charge because he had no criminal intent. So the current state of affairs with the state of Arkansas, to the best of my ability, I don't have a law degree or anything like that, and it'll be on par with what you're paying me, is that merely possessing a weapon in the state of Arkansas should not equal a crime. And we're defining weapons here as a handgun, knife, or club. That also brings up the great question, what if you have a rifle in your car? You know, is that going to be treated differently? So, not to mention the game and fish laws. If you're hunting, there's all these different things that get really complex. So merely possessing a weapon, you should not be charged with a crime in the state of Arkansas. But if you have a weapon and some kind of criminal intent, then you could potentially be charged. So that still leaves a big unanswered question, like, well, what about prohibited places? And so when people ask me, like, should I get a permit? And I'm like, well, here's the problem. If you don't have a concealed carry permit, basic or enhanced, you're not supposed to be within 1,000 feet of a school at all. You can have one potentially in your vehicle, but, you know, as far as state office, public parks, athletic events, if you're on a college campus, technically you're supposed to have an enhanced, and you can't enhance your constitutional carry or open carry. Also, as far as the alcohol, there's ABC regulations that would supersede, if you don't have a concealed carry or enhanced permit, would overrule that. And carrying openly in a college is expressly prohibited by law in ACA 573-322. So here's the thing. I don't think there's people out there trying to take out guys that are openly carrying a firearm when they go to Walmart or go about their normal day. I have my own opinions about open carry as far as it being I think it's not a smart tactical decision in a lot of situations, but I will absolutely defend your right to do it, and I think you do have a right to do it. But if you look at the law, the way it's written, whether we agree with it or not, whether we like it or not, there's still a lot of things that say, don't do this, don't carry here, you can't carry here. And if you look at the list, and that's what I was talking about, that attorney, one of Mr. Petrie's lawyers, on his website, he says constitutional carry, and he lists all these prohibited places. And I said, man, hey, about half of those, my students can carry there if they have an enhanced permit. And he goes, well, yeah, technically. So it's like, it's one of those things that I say, if you get a concealed carry permit, great. If you have one, great. I recommend go ahead, get the enhanced, get everything you can. At the end of the day, as long as you're respectful and not causing a problem, not breaking the law, like I said before, you should not be charged with a crime merely for possessing a weapon. But that doesn't mean we don't still have a lot of laws in the books that could potentially jam you up, and maybe in other jurisdictions, in other areas of the state where it might be an issue. So far, this area seems have their head pretty level with this kind, at least the prosecutors, not necessarily some of the people here, but as far as not trying to hammer people on weapons charges. So I think we're in pretty good position there, and I would use it kind of as a backup plan, that if you are in a place that's prohibited, and here's the thing, guys, and I'm not telling you to break the law, but the way it's written, knowingly or unknowingly, if you don't see the sign or don't know it's prohibited, and you're caught, boom, hey, you can't have a gun in here. As far as the law goes, you're pretty much good unless you now create a problem, because the statute doesn't say, hey, you should have known. It says once you're informed, you haven't created a violation unless you stay there after you've been told to leave or come back again. So, like I said, I'm not telling you to break the law, but in the eyes of, unless you admit that you knew and you did it just to get in trouble or cause problems, just be okay, be respectful, and go on about your business, and you shouldn't have a problem. And also understand that it's just private property rights, guys. If you don't want people to come and do what they want to do on your property, then you got to respect other people's private property too, even if we don't necessarily agree with their political ideas or whatever when it comes to this kind of stuff. So it's just about personal property rights. Alrighty, well, I think I beat that up enough. Like I said, reach out to us if you need a renewal on some other private training. We're happy to help you out with that. Our upcoming classes, we have one this weekend. It's going to be basic and enhanced. And then we have one in April, May. We basically have one a month going forward. Other than that, any questions? I'm going to switch over. I can see the YouTube stuff here. Thank you, Jimmy. What do you think of a situation of I missed the sign on the door? Well, here's the thing. If you did miss the sign, literally, whether you're being honest or not, when it comes to proving that, it's not really an aspect of the crime. Like I said, if, let's say you go into, I don't know, you go into the mall and there's a sign that says no guns. You just walk right by it. Somebody in the mall sees you and calls 911 and the police show up. The police show up and say, hey, man, you're not supposed to have any guns in here. And he's like, hey, as long as there's not that moment in time, literally, if you say, yeah, I knew it was, and I'm trying to show that this is Second Amendment and you can't take my rights away, and you start screaming like a maniac and acting a fool and scaring people, then, well, you could likely get arrested for maybe disorderly conduct or something. But if all the officer knows is, oh, I'm sorry, I don't want a problem, I'll put it in my vehicle, and I'm not trying to upset anybody, I'm not breaking the law, or at least I wasn't intending to, the elements aren't there. The cop can't arrest you and charge you for a crime, this particular crime, unless you have some kind of criminal intent. He has to prove criminal intent. And not seeing a sign on the door, intentionally or otherwise, because how do we know that? The cop can't read your mind, unless you tell on yourself, I guess. But even then, we have parts of the statute, as far as concealed carry, where it clarifies that a violation only occurs, as far as a prohibited place violation, only occurs if, one, once you're advised to leave or asked to leave, you refuse to leave, which here, guys, is private property rights. If I say, hey, I need you to leave my store, I need you to go, and you don't leave, that's criminal trespass. It's already covered. The gun is, just one other factor, not even really a factor in it. So as long as once you're asked to leave, if you leave, you should be fine. And the other thing is, you don't leave, or two, you come right back and carry your gun again, saying, oh, I don't care, and then cause a problem. You could potentially be charged. But even then, guys, I think probably the only thing the officer is going to charge you with is trespass, criminal trespass. I don't think it's going to be a carrying a weapon charge. I mean, it could be, but I would be really surprised, absent any other facts. I just don't think that's how it's going to play out. Let's see here. I guess we don't have any. It doesn't look like we have any comments on the Facebook side. So, I think about it. We're about just a little under 30 minutes. It's not too bad. I don't want to take too much of your guys' time this evening. It's obviously starting to get dark out here. So, if you guys have any other questions, feel free to hit us up. I know a lot of you guys are going to be seeing this recorded after the fact, so feel free to email us, info@nwadefense.com, or go to our website, messages on Facebook, whatever. We'd be more than happy to try to answer your questions and help you with these kind of topics. I know some of them are kind of complicated, but honestly, guys, they're typically can be made simpler than they are. You just need to focus on what's important. Defend yourself when it's justified, address that threat, and if it's not, just don't let yourself get drawn into drama that escalates into a problem, because that's Hey, there you are, Art. Glad you made it. He's the reason I'm on YouTube too, because of the we're having issues on the Facebook side. So, okay. Now I lost my train of thought. Just keep it simple, guys, and focus on the elements of absolutely when it's necessary. You guys should be fine in most situations. But anyways, I'm going to go ahead and end this thing. Thank you as well. Thanks for tuning in. And if you're watching this after the fact, thank you for putting up with me for 30 minutes and listening to me talk. And if you have any questions, let me know. We're happy to help. Thank you, guys. Hope you have a good night. Have a good week. Bye-bye.